Hello everyone. Welcome to Net Diligence Virtual Cyber Risk Summit. My name is Heather Osborne and I'm the Director of Global Events and Programming at Net Diligence, a cyber risk assessment and data breach services company. Net Diligence is pleased to bring our thought-leading content to the virtual space with this new webinar series. Visit our website at www.netdiligence.com to get more information about our upcoming webinars and in-person events. Before we begin, I'd like to extend our heartfelt gratitude to our virtual Cyber Risk Summit sponsors, particularly Aspen Insurance, our diamond sponsor. I'd also like to thank our 100+ speakers for bringing their thought leadership to our program. For today's webinar, we will be using the ON24 platform. Right now, you should be viewing the ON24 dashboard, which shows the live viewing screen. During the webcast, all participants will be in listen-only mode. Today's presentation is slated for approximately 45 minutes, with 15 minutes at the end for questions. Our panel of speakers will be taking questions throughout the session via the questions widget. Please type in questions during the presentation and click submit. If your question is of immediate import or concerns technical problems, you will receive an immediate answer by text. You can also find a widget entitled Resources, where you can download assets provided by the speakers and sponsors for each webinar. Just click the resource in the box and it will be automatically downloaded. If you are interested in receiving CLE or CE accreditation for this program, you must stay on for the full duration of the webinar and answer 3 polling questions that will appear during the course of the program. Additionally, please fill out the participant information questions. This will ensure that you are correctly matched to the state and professional organization. As a reminder, this webcast is being recorded. After the presentation, you will receive an archive link for further review or for sharing. The webinar will also be available for future viewing on our website. Again, thank you for joining the Net Diligence Virtual Cyber Risk Summit. We hope you enjoy the program.
Hi, everyone. Welcome to this session of Net Diligence. We are covering the session on wrongful use and inadequate disclosure. I am the moderator, Mark Mao of Boies, Schiller, Flexner, and with me today is a very esteemed panel of 4 other panelists who I will allow them to, introduce themselves. I guess starting with Rich.
Thank you, Mark. My name is Rich Sheridan. I'm the Chief Claims Officer at Berkley Cyber Risk Solutions, and happy to be joining my fellow panelists.
Hi, Chris Keegan here. I'm the leader of the cyber team at Beecher Carlson. We're an insurance broker.
Laurie?
And I'm Laurie Kamaiko. I'm Chair of Cyber Insurance at the law firm of Saul, Ewing, Arnstein, and Lehr.
And my name is John Yanchunis. I run the class action practice at the law firm of Morgan & Morgan and have a substantial practice and have for some time in the area of privacy litigation on behalf of consumers.
Great. Thank you, everybody. It's a real honor to be, moderating this very esteemed panel. Before we kind of go on to the contents of the rest of the presentation, I just want to note that in this presentation, you're going to have a total of 3 different sections where, in order for you to get your continuing credits in education, you will need to answer polling questions. So, one of those slides is coming up. What's going to happen is when we hit that slide, I am going to read the question. I'm going to give you a little bit of time for you to answer that. So if there's a little bit of silence on the recording, it is not because your recording is somehow lagging or has become broken. Streaming is not gone. All that's simply happening is that we just want to make sure that you have about 20 seconds or so in order to be able to answer the polling question so that you can get your credit. All right, so first polling question. True or false? The global big data and business analytics market is expected to be valued at $275 billion US dollars by 2020. It's a true and false question, or you can answer unsure. So I'm going to give you a few seconds in order to answer that before we move on to the next slide. Okay, continuing with the presentation, let's go over our agenda a little bit. These are just kind of like the high points we are trying to hit in terms of the total areas that you're going to see us go through today in this 45-minute or so presentation. One of the areas we want to cover is the hazards of ensuring deliberate business practices that run afoul, potentially run afoul of new regulations. Secondly, we want to talk about rewarding coverage to avoid things like expanded exposures under the policy or what your, what the insurers may be applying for. Third, we want to talk about pricing for expanded exposures. You're going to see us talk about this probably a little bit more in the, what do we see in the future section. And then, you're also going to see impact on profitability by next wave of class actions or regulatory investigations, which actually I think is probably going to be one of the first areas in which we're going to be talking about with what I would say is probably, in some ways the godfather of plaintiff side, class actions for privacy, John Yanchunis. So John, I'm on the 5th slide right now, which is data breach versus data misuse cases. I'm hoping that maybe, you can help us cover, some of how this has evolved over the last, 2 decades, maybe starting with, Kirby versus AvMed in the Southern District Court of Florida, and then the INRI Google referral header, which I believe was in San Francisco. Please.
So let's think about the fact that information is the new oil. It has tremendous value in today's economy, and it has for some time, particularly in connection with the Internet. And some of the oldest privacy cases, oldest in the sense that some of the first in this arena are really not that old. I would begin with perhaps a case involving Curry versus AvMed. It was a data breach case involving the loss of information held by AvMed, a medical health provider, and the consequences of that act on the consumers whose information was held. That case, one of the first ones in the data breach arena, went up to the 11th Circuit Court of Appeals, and it was probably the first circuit court opinion on the type of connection that a consumer must establish before being able to advance a claim against a company that lost their data. More recent case, but certainly one that has been moving through the courts for some time, is the Google referral header case, in which individuals were given the belief, based upon disclosures, that their tracking history would not be used. That case did go up through the 9th Circuit and to the United States Supreme Court, although on, albeit a different issue, the way in which that case was settled, and it is now back in the lower courts for further resolution. There's some other really interesting cases that I'd like to talk about. One is a series of class actions under the Data Privacy Protection Act, which dealt with the way in which driver's license and motor vehicle information was being used despite that statute. Those class cases were settled beginning in 2008 in the Southern District of Florida. And what we see in these cases is progression of the types of litigation based upon how information is either lost in a data breach, a data compromise, which is where information is exposed without protection to the Internet, and then, of course, the types of cases we see today, the data misuse cases, where consumers are given the belief that, based upon representations of, say, talk about Facebook, how their information is to be used or disclosed, and they have privacy settings. And yet, despite those privacy settings, we know from the Cambridge Analytica case that information was being harvested from certain users and their friends. And in some respect, that's both a data breach case and a misuse precedent. One of the interesting things is that we're seeing, at least in the last 5 or 6 years, was the application of 19th century legal principles to 21st century technology. In other words, the law was trying to catch up with the way in which information was being used, because privacy, the concept of privacy in this country arose from cases in the 1800s. We've now seen more courts becoming more educated about how privacy breach, privacy data misuse cases can be addressed through litigation. And then, of course, we see any number of states moving towards protecting consumers and giving consumers more rights. Historically, and historically is only really within the last 10 years, privacy advocates like myself had to use these common law concepts that were hammered out or arose from cases in the 1800s, along with consumer protection statutes. But today, we have the California Consumer Privacy Act, which provides robust protection for at least those consumers who reside in California. There are some other states moving to advance protection. There's absolutely no federal legislation on the horizon that I can see. So we may end up with simply a patchwork of 50 state laws to protect consumers' privacy. One of the other things we've seen is the evolution of how consumers, or what consumers must be able to demonstrate in order to pursue a privacy case. Spokio, which is mentioned on the slide here, is one which addressed the issue of Article 3 standing in federal court for a consumer to be able to advance his or her claim. And in this case, again, the Supreme Court talked about what needed to occur for a consumer to have standing, and this case was sent back to the lower courts for further development. So we're in an entirely new area. Thank you for referring to me as the godfather and not the grandfather. But again, one of the great things that Mark and I have talked about is we are in somewhat of the Wild West. We're dealing with a development of both technology, the way in which information is used, and the way in which it's misused or lost, and the repercussions of that. It is a very exciting time for a privacy advocate, and one who, like Mark, continues to want to protect consumers' interest, and yet also understanding that there's an entire section of our economy in this country, in this world, which needs to be able to use information, and consumers should be informed when it's being used in some type of commercial context.
Thanks for that, John. If I may actually just kind of like ask you, I think one case I left out on the slide as I'm looking at it, I totally almost forgot, and you know, it's incredible that's actually forgotten, is actually the Clapper versus U.S. case, which I think was actually technically a data misuse case. I actually don't know the background. What is the reason why everybody started relying on that as a matter of like a challenge to Article 3 standing? Do you actually know the question to that? Sorry, I know I'm kind of going off presentation a little bit, but I think that's a fascinating question because that's clearly talked about in Spokio, right?
Right. Clapper was a case that arose from certain privacy advocates who were concerned about the way the government was collecting information. It was collection activity that arose following the tragedy of 9/11 and a desire on the part of government to make certain that information could be gathered to protect the security of people in this country. These privacy advocates were very concerned about how that information might be collected and what privacy protections they had. And the Supreme Court focused on the issue of standing. That no one who was advocating this interest had yet established how they were affected by the collection and use of that information. So the issue of Article 3 standing arose out of Clapper, and Clapper was relied upon to argue by defendants some of our early privacy cases and why those cases should not stand. courts began to develop the concept of standing, the Neiman Marcus case, the P.F. Chang's case, any number of cases out of Judge Koh in the Northern District of California, San Jose Division. And then the court spoke about Article 3 standing in Spokio. So there's really an evolution of the concept of standing first in Clapper and then in Spokio, and then it's been left to the district courts and, of course, the circuit courts around the country to kind of further define the concept of standing. And you've seen any number of circuits like the 11th, the 2nd, the 7th, the 6th, the 9th, and the D.C. Circuit, and now the 4th, that have all taken very enlightened approaches to this issue of standing. I think and the first, I'm incorrect about the second. The second in the Michaels decision, I don't think had the appropriate facts. That is one which I think the court needs to address the issues of standing like the other circuits have done. And I don't see a case on the horizon where the court will have a chance to review the issue on a conflict. Again, they could have done that, I think, in the Goss case, the NRA Google referral header case. But instead what they did was they sent that back to the lower court to develop. And the issue there was, did the plaintiffs in that case really have standing to advance a claim against Google, even though Google had settled that as a class case? Ted Frank took that up on the issue of the appropriateness of a cypre where nobody was getting any money except for the cypre recipients. And it just shows you what can happen when cases go up. They have unintended consequences, and that would be one in which that occurred.
Right, and then I know this is a little bit of the final question on this slide, and I know maybe this is a little bit of fighting words, but for the coverage attorneys. But my question is actually, I've always found the Cambridge Analytica case fascinating because it's kind of hard to classify as to along kind of like more traditional lines. Is that a data breach case or a data misuse case? Because you literally have an authorized party who then ended up using it for unauthorized purposes, but potentially further down the line. Do you have any predictions on that, John? How do you think Cambridge Analytica will affect us in terms of being, as precedents?
So I think it'll be more another evolution of the same type of cases that we've seen. Judge Chabria has already issued an order on a motion to dismiss where he gave some incredible insights as to the expectation of privacy by consumers. And here we involve, what occurred was, again, people had their information scraped by a third-party applicator who had access for a specific purpose to certain data, and then we went beyond those access permissions and then began to scrape information from people's Facebook's account who had never given consent. The issue for Facebook is what type of control did they have to prevent that activity? So in a way, it's a convergence of both a data breach and a data misuse, I think, ultimately. And I'm not in leadership in that case, but I did file a class case as a part of many, and I believe ultimately the consumers will prevail in that case. More likely the case will get settled. I think there are some certifiable issues. Recently, last year, I certified a case against Facebook for a data breach representing U.S. consumers. It was under B2 for injunctive relief. The judge was not impressed with the repercussions of that breach with respect to the client the class rep I represented, but clearly that case established a roadmap as to how you could certify a case for damages, and I believe in this coming year and next year you'll see more cases certified by courts for damages as we begin to grapple with and address some of the knotty issues around how do you certify a damage class in this area.
Thank you, John. That's super helpful. I think that question of certifiability is especially interesting in cases not involving statutory damages. But I'm guessing it's probably a little bit easier in cases where, like wiretap claims or FIPA claims. That's probably a little bit less of an issue. So thanks again, John, for coverage on all of that. My next question is kind of, for those who want to opine on insurance coverage, coverage for misuse of data. What type of data misuse cases have been the issue of coverage disputes, recently or currently? And please, presenters, keep in mind that audience may not be able to see you, so when you kind of speak in, you might want to just identify yourself if you don't mind. Thank you.
Well, this is Laurie Kamaiko, and I can start the discussion, although I'm sure my colleagues may have some thoughts as well, which is that, as John has said, this is a new area. This is not your typical areas of is there identity theft or risk of identity theft necessarily coming from this or cybersecurity. It's more about privacy issues. And therefore, a lot of the case law that we have really doesn't apply yet here. And most of what we might think of as coverage disputes are behind the scenes as opposed to in front of them. I mean, before you get to misuse, you get to data collection. And that's really what some of the issues are focusing on here. In the past, the body of case law about data collection was probably primarily in the California Song-Beverly zip code collection cases, and there were a number of decisions that came out from the CGL policy issues as to whether they covered, but not under cyber policies. So at least what I'm seeing is in this new range of cases, there's a real focus on, before we even get to the misuse, what about the collection? Is the entity that's collecting the data really the one that's allegedly misusing it? I mean, for example, you have the Facebook versus Cambridge Analytica one that you were talking about. And are this type of activity one that is really intended to be covered and is covered? For example, some policies will only have wrongful collection or unintentional collection provisions. They may have exclusions for violation of consumer protection statutes or unfair trade practices. There's going to be a lot more, I think, issues maybe resolved behind the scenes, but dealing with whether or not this is the kind of conduct that was ever intended to be covered by a typical cyber insurance policy. And when we talk about coverage for violation of a privacy law, is the policy talking broadly about coverage of a privacy law, or is it having some sort of subset of those privacy laws regarding the security of information, for example?
Right. And this is Rich Sheridan from Berkley, and I'm pretty much going to piggyback on what Laurie was saying. I'm in pretty much complete agreement with it. I have not seen any litigated disputes in this area, and I think the issues that we do see behind the scene do relate to when you're dealing with sort of a collection of information type issue. Is it something that an insuring agreement contemplates for coverage under a cyber policy? I would say the older cyber policies probably not so much. More recently, probably yes, it does fall within some sort of privacy type violation. Typically, is what's alleged. But then policies often have exclusions related to wrongful collection, and those exclusions can vary pretty significantly in how they're worded too. So, and when they're sort of broadly stated as wrongful collection, the exclusion is usually a lot more than wrongful collection. That's just sort of the name that it's captured under, but the exclusion is usually broader than that. And and today we're seeing policies that actually affirmatively grant coverage for wrongful collection, sometimes in the policy form, often by endorsement, could be sublimited. So I think this is a type of loss that I think cyber policies often didn't contemplate, but I think good insurers now should be absolutely contemplating in light of all the statutes that are out there that relate to wrongful collection. Things like the Illinois Biometric Information Privacy Act, BIPA. We're going to talk about a couple of type of wrongful collection issues a little bit later. The Michigan VRPA as well. So, this is something that insurers should be aware of. If they're not, really, they really ought to be. And I think, Chris, as a broker, probably, sees insurers that are fully schooled on these issues and look to, the type of insured and see what they do as far as collecting information and how they tailor policies and what they're willing to cover.
Yeah, thanks, Rich, and I'll follow up on that and agree with both you and Laurie. It's certainly been a spectrum of coverage. I think in the early days, it's the nature of the policies themselves that when we first started to sell cyber insurance, the things on people's minds were claims out of such things as the target breach, where it was really clear that a hacker, a third-party hacker, had got into a system, and that's what we were trying to cover. I think it's interesting that Laurie mentions the Song Beverly legislation, which came up, and I think that was the first time I remember. And Rich, you say that there hasn't been any cases that you know of, but there certainly have been some disagreements on what's covered and what's not. I think that Song Beverly example, I do remember some claims being paid under that by the insurance companies, but soon afterwards they put in exclusions for that type of situation because it became clear that they weren't intending to cover that. And so, as time has gone on with GDPR and new statutes coming in with slightly different nuances and results, I think we're seeing people like me in the marketplace who are looking to say that these are types of things that should be covered under a well-crafted, broad cyber policy, although, we also are well aware that at some stage when we go as far as ensuring such things as BIPA, as you, Rich, mentioned, or things like statutes such as GDPR, to some degree, we're ensuring, the compliance of a company, and something that the management of a company has some strong control over. And I think, sometimes I think maybe that's the Facebook example that John is mentioning. Did Facebook have enough control over the situation actually to be able to prevent the disclosure of that information? So those issues are becoming issues. I think the broadest policies that we do see out there, I think that they do cover those, almost all of those sort of situations. I think the one situation I'll just mention is sort of the current situation I think that we're starting to look at in the going back to work from working from home situation, where there's going to be contact tracing information that's starting to be collected, healthcare information on employees that's starting to be collected, and some of the exclusions. Laurie mentioned some consumer privacy statutes, consumer privacy statutes, collection of information, exclusions. There's one that sort of jumps out at me in that type of situation, which is an exclusion which all policies have. It's an intentional violation of regulations by a senior person. And usually there's, under the best policy, some level of severability there. But at some stage, if companies are making intentional decisions about how they collect and use information, there is a level of reluctance on the part of insurance companies to say, we will cover that, I think largely because they look at some of those decisions as business decisions. But the broadest of policies, I think, are willing to go there, largely because this continues to be a competitive marketplace, and where statutes like GDPR come into effect, there's an expectation from purchasers of the insurance that it will be covered.
Right. So sorry,
this is anybody else to talk that
go ahead.
Pass it on to. So back to you, Mark.
Oh no. I was simply going to say that although I'm on panel for the the high stakes litigation for three of the largest carriers on the market, I'm often also on the side of large tech companies. I represent some of the largest social media platforms, and I can certainly see it from the perspective of the platforms that in terms of some of their partnerships, it's not even really an issue of wrongful collection. It's just that, that sometimes they end up partnering up with companies that are looking to kind of, monetize off of their data in a way in which either, was not authorized or was in a way which is not, conceived. I think that is actually the very definition of disruptive technology sometimes. So I would think that, at least from the perspective of these, more enterprising kind of like technology companies, they would like, broader coverages rather than narrower, just because, in the areas of high tech, you're constantly seeing things evolve, and lack of ability to be able to anticipate how it will change is actually in some ways the very definition of disruption, right? So I think it creates some, both business opportunities for those willing to take risks and also some huge risks for those who do take the risks. So, I think we'll be able to see that a little more clearly in some of the future slides. So the next area we're going to jump into, but I'm going to scroll over our second polling question first, is the area we're going to jump into is we're going to use specific scenarios, so we can kind of talk about some potential issues that might be flagged from a coverage perspective in the following kind of cases, okay? But before that, we're going to do our polling question, second one. So true or false, the wrongful use of data is really not a big deal if you apologize in writing to your customers. Again, the question is true or false, the wrongful use of data is really not a big deal if you apologize in writing to your customers. I'll give you about 15 seconds to answer that. Okay, so full disclaimer on behalf of our esteemed panel of panelists. None of these hypotheticals were just issue spotting, things to think about, things for all of us to chew on. It's not binding on any carrier or any particular policy, but I just thought that these were some interesting examples for us to kind of talk through. So the first one, obviously any panelist could kind of like interject and give some thoughts, but is Lynn versus Crane Communications. This Virginia plaintiff alleges that Michigan magazine publisher misused readership information by giving its data miners, marketers, and third parties in contravention of Michigan VRPA. This is a pretty high-stakes litigation here if you know anything about how some of the VRPA settlements have paid out. So panelists, particularly those on the coverage front, what issues might this insured here be dealing with?
This is Rich.
This is Chris.
Go ahead, Chris.
Go ahead, Rich.
All right, I'll lead off on this one. You can lead off on the next one then. So, or you or Laurie on the next one. And obviously, please feel free to chime in. I would say the issues that you're facing here, first of all, is under VRPA, is it personal information that's being collected? I would say under most policies, and again, on cyber policies, every cyber policy is a little bit different, or almost everyone's a little bit different. So what's considered personal information can vary from policy to policy. I would anticipate that most cyber policies would consider the readership information that they're giving away to be personal information. But again, it would be something that would have to be looked at. Is this collection of information unauthorized? Is something else that you would probably have to look at, because it's usually cyber policies will provide coverage when it's unauthorized information that's being disclosed. I again would think that this would be, and the allegations are probably that it was unauthorized, hence the claim of the violation of the statute. They are sharing it with outside parties, so that part seems clear. And then, you have to look. I mean, conceivably, some cyber policies could have specific exclusions, like many policies have exclusions for TCPA. Is the Michigan VRPA sometimes excluded under cyber policies? I don't know the answer to that question. I suppose it's possible. I haven't seen it, but I suppose it's possible. And then you come back to which we kind of touched upon before, just the general wrongful collection exclusion. First of all, is there a wrongful collection exclusion in the policy? And if there is, how is it worded? Does it include, this kind of collection and or sharing of the information? And just stepping back on that a second, it is the collection of information, and again, I kind of touched on this before, but is that collection of information something that triggers the policy's insuring agreement? It probably would at today's day and age with cyber policies.
Great. That was pretty...
Chris,
sorry, go ahead, Chris.
I'll just add to that, if I may. Actually, I'll just go back to make one comment on your comment earlier before we got on the slide, mentioning that you work with social media companies, and I will say, the ability to provide, for the marketplace to provide insurance for companies in some sectors, when you have Google being fined $57 million by France and the GDPA, there's going to be, and that's a matter of record, there are probably not going to be many insurers that are going to be willing to jump in and say we'll back coverage for Google for lack of compliance under GDPR, at least not at a very significant premium. So but there are other parts of the marketplace which I think are perceived to be less risky, where the broadest coverage, I think that Rich is talking about, where there's often, like in the broadest affirmative coverages, where it's like collection, use, storage, cover all the sorts of uses of information. So if it's one of those types of clauses, in this case under Lynn, Crane Communications, I think certainly it would be picked up by the insuring clause. Then I think in the back end, you might want to be looking at some of the exclusions. Sometimes, there are agreements on websites, contractual agreements with clients about how information is used. There are exclusions in policies for breach of contract, but there's also exceptions to those exclusions as well. But that might be something that someone wants to look at in this case. And I think what I mentioned earlier about the intentional acts, intentional breach of regulations exclusion, where you have the management that is affirmatively making a decision that they're going to sell this information to data miners and in contravention of the statute, and they know about it, then certainly that's an issue that I believe someone like Rich would look at and raise.
Yep. Yeah, good point on the conduct exclusion. Absolutely. And again, most, which you kind of touched on before, most conduct, or at least a good exclusion obviously from a broker insured perspective, will have a carve out for the innocent insured. And oftentimes it requires a final adjudication as well. So even if even if you are asserting it, you need to have a final adjudication that the conduct was intentionally in violation of the law, which, as most people know, is very difficult to get. So in most instances, the insurer will be involved in the matter, at least on the defense side anyway. So.
Got it.
Yeah.
Sorry, second hypothetical here. I think this is hugely interesting because I think clickstream and, browsing data is kind of like one of the biggest things that's being mined that I actually don't see a terrible amount of case law on right now. So this one's interesting for me. Popa versus Harriet Carter Gifts. This is in Pennsylvania. It alleges that Harriet Carter, an online shopping website, used Navistone software and code to track shoppers' activities on the shopping portal, including keystrokes and mouse strokes. What are the potential insurance coverage issues here? You can say, if a lot of the things were covered before, but I think the audience probably would be curious about, in addition to what you discussed before, are there other issues when it comes to kind of like this type of like activity and content tracking?
I can jump in a little bit here because it really applies to not just Popa, but certainly the ones that the ones that are in California right now. Are these deliberate business practices for the tracking, or is it just an inadvertent, unauthorized access to information? That can make a difference. And when we're dealing with issues such as deliberate business practices, I know we've talked about the intentional acts exclusion, but it's also intentional and foreseeable. And there may be issues also under, for example, certain states like California, where there are statutes that provide that an insurer is not liable for a loss caused by a willful act of the insured. And while, yes, you also have to look at whether, what the damages were, are we at a point where it would be considered to be foreseeable that somebody is doing certain deliberate collection practices that a violation is foreseeable? Or the collection of, the third example, I'm jumping a little bit ahead, that the collection of information of minors would be foreseeable. So I think when we're getting into this issue of the business model of the policyholder, that their insurance issues are a little bit more complex than just, is it under the insuring agreement or does it fall squarely within a typical exclusion? There may be other laws involved that limit the ability of an insurer actually to provide for the loss. That would be different than whether we can separately discuss whether there's a duty to defend until certain of the facts are established. But when it comes to coverage of resulting losses, and certainly when it comes to fines and penalties, there's going to be a lot more insurance issues.
Got it. All right. So this issue.
Add to that and say that I think under the earlier insurance policies, this is the sort of situation where you may have an issue if you are covering. I mean, some of the earlier policies really limited it to theft of information, and this clearly isn't theft of information. Mm-hmm. Whereas then I think the next phase of policies talked about breach or unauthorized access and unauthorized use. I think are the words that get used. Mm-hmm. The question I think I see here is this unauthorized? It may not be. There may be some type of affirmative conduct that you accept when you go into the shopping portal. I'm sure some of you lawyers have allowed companies when you're helping them put their privacy policies together, making sure that they get appropriate consents. And once you've got consent, maybe that action is not unauthorized. So there may be under some of the narrower policies issues coming up arising from that type of wording. But I think under the broadest collection wording, this seems to be clearly a collection and use of information that would be covered under those broadest insuring clauses.
And I would just chime in with one quick note on this one. I wonder, is it actually personal information that's being collected? You're on the particular website, and they're tracking your information on the website. I think maybe the little glitch here is that arguably they're sharing it with a third party, and that might be an unauthorized part of it. But for Harriet Carter themselves, just tracking where a shopper is, it would be sort of, I would analogize it to being in their store and somebody shopping around and them watching what the person's doing. But again, that's just a thought, and different policies define personal information differently. So just something that I would explore if I had this claim and was looking at it.
Good point.
Okay, so I think this puts us right into this last example here, which is tracking allegations against YouTube and Google based on commercial exploitation of kids. I think this is where the intentional versus unintentional consent versus lack of consent, really becomes, in my opinion, difficult because I for one of the largest social media platforms, I was involved in the case. One of these cases involving minors as well, and the question always there is are minors capable of giving consent? Is the collection wrongful? If the parents didn't give valid releases, that's legal under Popa. So my question is, how has that been dealt with, and what kind of coverage cases or coverage issues has that usually created?
I think back to our commentary under the broadest insuring clauses, and maybe one which we haven't mentioned so far, but is in quite a number of policies, is there are triggers of insurance which talk about breach, collection of use, but there's also quite often another insuring provision under the privacy component of a policy which talks about just quite simply breach of a privacy regulation. And I think when they define breach of privacy regulations, it's usually relatively broadly defined. Quite often they give examples what those types of legislation is, and children's COPA is often included in those lists of the type of information. So if you've got a policy like that, it is and there's no exclusion for the use or collection of information, then this is probably something where you have that type of trigger that it would likely to fall under that trigger fairly clearly, at least from a brokerage point of view. I pass it over to the people who represent the insurance companies. Rich?
Again, it will depend on the policy, and I do agree on the broad policies. This, almost certainly on the broadest policies, this would probably be the type of event that would trigger the insuring agreement.
Thank you, Rich. So, kind of going towards the end of the presentation here, and I just want to talk real quickly here on this 10th slide here, which is how to better assess insureds and losses. As you can tell, at the underwriting stage and at the application stage, there are a lot of things to consider. The basic thing, obviously, is that you want to understand the insured's product. Something that's more advanced is that you actually want to understand the insured's futures and plans. But kind of like the master class level stuff is understanding how the insured's products may actually be. It may actually create various synergies with partners and product users, because a lot of times, whether you want to call it unauthorized use, unauthorized dissemination, disproportionate, use of data, or however the issue may come up, is something that's a result of lack of true understanding of what is going on with the product. So you want to make sure your underwriters and also your insured applicants, are able to talk about all of this intelligently. So from here, I want to go on to the last slide. And obviously, we would value the opinions of John, in addition to, Laurie, Rich, and Chris, which is that predictions for the future of data misuse cases. John, any thoughts about where you think we're going to be going? And then we would love for the carriers and also for the brokers to basically, opine in on what the coverage scene for that would actually look like.
So, I indicated earlier that I thought that there was not yet on the horizon any federal legislation that I think might pass. That might change in the upcoming year or year beyond. Certainly there are going to be other states following the lead of California to give consumers the right to better control their data and how it's used. And as a result of that, and again, understanding that data has tremendous value in the economy today, it's no surprise that some of the largest corporations in the world are those that don't make anything. Facebook, Google, these are companies that, base their revenue on using information of consumers and monetizing it, whether it be to advertisers or others. So I think you're going to continue to see an expansion of data misuse cases, without question. Again, one of the things that I thought was kind of a change in perspective by judges is in the OPM data breach, which affected approximately 22 million federal employees and contractors who had their information stored at OPM, including all federal judges, all FBI agents, all DEA agents. And I'm litigating that case with others before Judge Amy Jackson in the District Court of in Washington. And I think the point I'm trying to make is the judges in that case, since they're all class members, began to think about that their own ox was being gored, and they began to rethink about how their privacy might be stored. And I think it opened up judges' minds to some of these now misuse cases that we're seeing. And I have any number of them on file. And again, I think they relate to the fact that consumers are not given disclosures as to how their information is used. There's a lack, perhaps, of sophistication on the part of consumers as to, when that information is given, whether it be in some type of little click box that has pages and pages and pages of disclosure, but really is that sufficient under the law? And then in terms of what's disclosed, is the platform vendor, or I'll call them the defendant, as they are when I deal with them, are they using that information in accordance with what they're telling consumers? We mentioned the Cambridge Analytica case at the beginning of the program. So again, there's a tremendous amount of litigation that I think is coming down the pike, so to speak.
Those on behalf of brokers and coverage and carriers, any thoughts on those future of cases?
This is Laurie. It's just sort of focusing on the coverage aspect of that. What's become clear is that exposures are grossly expanding, aren't they? Both from the perspective of what's the privacy law and what is it covering, and therefore liability for the potential defendants, as John would call them, and for their insurers. And one of the predictions is that I think from the insurance company perspective, to be much more aware of that and look at the existing policy wordings that we have, for example, the definition of a privacy law and the scope of what you're covering, and make sure that A, it's what the insurer wants to cover, that B, it's what the policyholder expects to be covered, and C is the pricing of that, taking into account the exposures. So that's my prediction is more hopeful.
I'll jump in from a broker perspective. I think just looking forward, and I don't have the actual statistics at hand, but I know I have a slide in a slide deck which just talks about the number of IoT devices that are out there, but it's jumping from 2 to 20 to 50 and 100 billion, in a really short time period. And each one of those devices potentially is collecting information. So just the amount of information that's out there is just increasing at an incredible rate. I know there's a statistic out there that talks about the amount of information every 2 years that's being collected. I know there was a point in time where in a 2-year period we collected information on computer systems that was the amount of information that was same that would been collected in all time up to that point. So just the amount of information, and then I think the type of information. If Elon Musk has his way, we're going to be putting chips in people's brains at some point in time in the future, the close future, if he has his way. And you can only start to think about the type of information that might be collected and the laws that may come into effect that may be needed in order to control that information and require the protection of that information. And I think those laws will come into effect. I think we're just seeing the beginning of it. I think the next 10, 20 years, this will be a huge area of dispute and discussion and legislation. So all of that will require that the insurance markets respond. So I think we're going to see this just multiply in ways that are going to be huge.
Rich, any closing thoughts on kind of where you think that the insurance product or coverage might be going with regard to kind of like all these new issues and I guess potentially opportunities that are popping up for coverage?
Yep. What I would say is, we'll see with the CCPA kind of basically allowing enforcement action starting July 1st. I think I think insurers are going to be looking very closely at what happens there. Other states are clearly following that statute, providing statutory schemes for damages. But notwithstanding that, we're seeing some, as John I'm sure can attest to, we're seeing some traction on, on litigations with, under other statutory or non-statutory schemes. So, but with CCPA, that could be a game changer with state statutes, with with statutory damage schemes. And if there wind up being, really substantial losses coming out of that, insurers are probably going to have to step back and look at what they're covering, because right now a lot of insurers are providing extremely broad coverage under CCPA, for those kind of losses. So, we'll see. But, like you said, like Chris said, there's all these different risks that are still, kind of developing, and in ways that we don't even really contemplate. Like he talked about contact tracing, and the privacy issues surrounding that. That's something that was on nobody's radar screen going back like 3-4 months ago. And we continue to see these kind of risks develop. And I think insurers just have to keep a close eye on what the exposures are, and how they're developing. And if CCPA winds up bringing huge losses to insurers, that may revamp how they provide coverage. But again, we'll see. And there will always, when there are risks and exposures, the insurance market usually reacts in a way to provide coverage for those losses, but they have to do it obviously in a way that makes financial sense to them. So I think it's just going to be a fluid situation, and we'll see where the losses come and how they come, and insurers will react accordingly.
Okay, with that, we'll go to our last. Okay, last polling question. To best assess insureds, one needs to understand the insured's product, or an insured's future plans, or how the insured's product may create synergies with partners and product users, or all of the above. I'm going to give you about 10 to 15 seconds. So on behalf of all the sponsors and Net Diligence, we would like to thank our esteemed panel of speakers here today. And, any questions you submit, we will try to respond in writing by email, or you may contact one of us directly. Thank you very much.
Hi, I see we have a question. We don't have much time for live questions, but we selected one to answer. The question is, for claims arising out of the alleged misuse of data, can there be coverage under any policies other than cyber policies? Yes, if the claim arises out of the insured's provision of professional services for others, their E&O policy might provide coverage. If the allegations are that they're misusing employee data, their employment practices policy might apply. Of course, those policies could also have exclusions that might be applicable, but not all do, and sometimes those policies will provide coverage for these types of matters.